Good morning and good afternoon and good evening, colleagues. My name is Molly Steck. I am STM's General Counsel, and I'm delighted to welcome you to today's webinar on AI and intellectual property and copyright. We have a stellar panel to speak with you today. They are Pascal Hedgeholt, Senior Director of Content Protection at Wiley. He sits in London. Catherine Zoller-Rowland, Vice President and General Counsel from the Copyright Clearance Center. She's here with me on the East Coast of the United States. And Elizabeth Krosick, who is the Head of Government Relations for the European Union and the Global AI Policy Lead for RELX, and she sits in Brussels. Again, thank you for attending. My colleague Joris van Rossum moderated STM's first webinar on AI back in March. His event was entitled GPT-3 and the Future of Publishing and Academia, and I commend that webinar to you. It's recorded and available on STM's website. But for today's talk on AI and copyright, I'm just going to provide some background, a little bit of scene setting, and then I'll kick it over to Pascal to get us started. When I began looking at this topic, the AI copyright nexus, about 4 or 5 years ago, the two main AI questions for copyright were A, whether AI can be an author for purposes of copyright protection under the Berne Convention or domestic copyright laws, and B, whether the mass ingestion of copyrighted works to train AI constituted copyright infringement. I think today we're probably going to focus more on the second question than the first, but we'll see what our panelists have in store for us. To quickly set the scene for the copyright issues, and this will be a bit pedantic for some, but hopefully useful for others. The Berne Convention for the Protection of Literary and Artistic Works was adopted in 1886 and now has 181 member states, among which are the regions and countries we'll be talking about today. The Berne Convention includes provisions determining the minimum copyright protections to be granted to authors or right holders, basically subject to certain allowed reservations called limitations and exceptions. There are exclusive rights in a copyrighted work that belong to a right holder, including, most relevant to our conversation today, the right to make reproductions, the right to communicate to the public, the right to translate, and the right to make adaptations and arrangements. And there are other exclusive rights that are less relevant, but those are the ones I wanted to highlight. Although originality of a work is not addressed in Berne, it is built into domestic law. For example, in the United States, copyright adheres in original works of authorship. In the European Union, the CJEU has conferred copyright protection on works that are the result of an author's own intellectual creation. Countries implement the Berne Convention differently. One easy example is a closed list of exceptions that is common in civil law jurisdictions versus, for example, the fair use doctrine in the United States, or fair dealing in other common law countries. And I'm talking about these basics to frame the concerns and opportunities that AI may provide. Whether we're talking about machine learning ingestion or text and data mining, it's important to note that the rights of authors and right holders, for example, publishers, should be respected and that they're enshrined in black letter law. Licensing, of course, is beneficial for many reasons, not the least of which is that copyright holders hold the best rendition of their content. In the STM environment, that includes the version of record, scientific, technical, and medical journal articles that are enhanced by semantic enrichment, metadata tagging, and verified data. The law and the marketplace should continue to value and incentivize the creation of copyrightable works in this environment. One last set of points on backdrop. Lately, of course, countries are being confronted with lawsuits that have the potential to define the contours of the legal ingestion of copyrighted works. There's case law in the US and the UK, and I think Katie will touch on that. Or they're considering or have already implemented legislation that potentially accomplishes that goal, for example, in the EU and Japan. G7 leaders issued a statement on May 20th about trustworthy AI, and I think Elizabeth might touch on that. And the US-EU Trade and Technology Council, the TTC, reaffirmed in a statement on May 31st their commitment to a risk-based approach to AI that advances trustworthy and responsible AI technologies. Last 3 points. It's important to keep in mind, of course, that all these countries we're talking about today must still comply with the Berne Convention. It's also important to keep in mind that the cross-border implications are complex and that despite territoriality, meaning that each country has its own copyright law that applies within its territory, AI by its nature will generally implicate the laws of many different jurisdictions. And of course, lastly, important to keep in mind that the term AI is not monolithic and that there is unlikely a one-size-fits-all approach to govern it. One last point about housekeeping, please put your, to the audience, please put your questions in the Q&A. And I will get to those at the end. We're going to have the 3 presentations. We'll have a bit of a conversation among the panelists, and then we'll turn to audience Q&A. And with that, I'd like to turn the floor over to Pascal. Thank you.
Thank you so much, Molly. I will share my screen. And please confirm that you can see it properly. Wonderful.
Yeah.
So thank you so much to STM for organizing this and for discussing this topic today. I think it's logically a very important topic, not only because it's like a buzzword now and everybody's using it and publishing about it, and the disruptive consequences sometimes of the introduction of this technology, but it means a lot for our industry in particular, the way in which our content is being treated. And what it can mean for jobs and roles in our space. So it's an all-encompassing technology with many, many different consequences, as you will see in a moment. And thank you for joining us today. We really appreciate it. So first of all, what is it that we did for you? We would like to take you by the hand and take you through a number of conversations that we had with AI. And with that, I mean with all 3 AI services, Google Bard, ChatGPT, and Bing Chat. But before I go into detail as to what we have discussed with these AI services, with the applications, just a little disclaimer indicating that, like Molly just said, there's no such thing as one sort of static concept of AI. It's super dynamic. If you submit the same questions, same prompts to an AI service, you will get different answers every time you ask the question. And it changes on the basis of not only the restrictions or the guardrails that the makers or developers put in place, but also the prompts that we give the AI services ourselves and the content that we may or may not be uploading and sharing with AI, right? So it changes every day. And, you know, today's conversation will probably be very different when we have it next year, right? If you want to have more details about my statements, please go look at that Substack, which you see at the bottom right as p4sc4l.substack.com, and you can find all the evidence and all the information that I'm discussing today. First and foremost, when you start to use ChatGPT for the first time, you can already, look at these disclaimers that they show and discuss that for days, if not longer, because what they indicate is when you use our service, your conversations may be reviewed by our AI trainers, so by humans. They also advise you not to share any sensitive information. And thirdly, they indicate that when you use the service, you may use plugins that are powered by third-party applications that are not controlled by the developer of ChatGPT, OpenAI. So make sure you trust the plugin before installation. And plugins, just so you know, allow you to, for example, go on the open internet and look for information there, or they allow you and the AI to share information amongst each other and have AI analyze it, right? They also indicate that when you use a plugin, it may share information about the conversation and about your country or state with other entities or parties, right? So I think that by itself should warn you to be very cautious as to how you use ChatGPT or other AIs within your business. And as you know, some major businesses have already prohibited the use internally. When you talk to all 3 AI services, you start to recognize the fact that they represent very different individuals, right? So if I talk to Google Bard, it comes across as the persona of a teacher. It tends to be quite neutral and objective and doesn't engage in very prosaic or even, emotional conversations, which ChatGPT and Bing Chat are actually doing. With ChatGPT, I always compare that to an anarcho-libertarian. I would advise to Google that one, and you can find more information, especially if you talk about the concept of copyright, intellectual property protection, and freedom of information. When I talk to Bing Chat, it doesn't allow me to ask questions about itself. So I call that one the introvert, right? It doesn't want to talk about its specifications or guardrails and rules. So the first thing that I wanted to flag as on the basis of the conversations that I had is the fact that there are a lot of things you're not allowed to talk about, right? So you may have seen comments in the news of some industry leaders who said we need a truth GPT. So I can sort of understand that because I have the suspicion that many of these services work with keyword lists or are monitoring the prompts or are simply keeping track of topics that they don't want to facilitate because, you know, they don't want the AI to give advice as to how to plan a terrorist attack or things like that. So just be mindful of the fact that there are a lot of topics that you cannot even discuss. And Google Bard admitted to the fact that that list changes on a daily basis. So logically, if there are such restrictions and guardrails, the output might be limited or restricted, and as such, it could affect the truth that the AI may convey to you because it's simply not allowed to say certain things about certain topics. But more importantly, as ChatGPT indicated itself, there's this component of moderation, right? And moderation can relate to something that you know, the AI shouldn't be conveying, or that maybe you shouldn't be asking the AI to discuss. But it can also relate to how good the feedback to your question is. So human moderators are also rating responses and the quality of the responses that the AI provides to you when you prompt it. All of those factors influence the quality of the output that the AI provides you with. And as such, when, you know, there are so many factors that are influencing the process, we have continued these conversations and we're able to identify 10, I think, let's say, topics of concern, right? The first one being the bias. So that relates to the quality of the response, the ideology behind it, maybe some political views, etc., that you can differentiate. So it's important to take that into account. Again, the censorship, that are certain conversations that are a no-go. The AI will shut down if you try to do it. Human intervention, that can influence what you get back from the AI. What happens to your data that you input or sometimes upload to the AI through plugins? Defamation, as you may have seen in the news, AI can be unhinged. It can be hallucinating, as they say. So it can draw all sorts of correlations that may have negative consequences to certain individuals. Transparency. Now, if you ask AI what guidelines and what best practices and ethical rules should you be following, it gives you really good answers. All three AI services do that. If you then subsequently ask it, are you adhering to those guidelines? It cannot answer your question, right? So it's not allowed to. That's something to keep in mind as well. That's why some rights owners are asking for audits. Copyright is what we will discuss today. There are many elements to that, but I just want you to know that it's not only about training data, it's also about whether or not the AI can link to anything that's available online in real time, or whether it allows for you to upload content to it for further analysis. All that influences that discussion. Countries may have different regulation that the AI may not be in compliance with as of yet. There may be an issue in relation to affordability, whether people can pay for a ChatGPT subscription in some countries, because there is a premium version available for $20 per month. And sustainability, right? This is one of the, and AI acknowledges this, most expensive and impactful when it comes to environment technologies. And we will hear more about this in the future, right? Because it may have negative effects on our environment. So taking everything into account, we asked the question to all three AI services, can you be considered, can use of your service be considered as safe? And it actually says no, right? So all three services indicate that no, you should be careful with how you use our output, what you do with it, and how you interpret it. And we don't think that right now the use of AI actually is safe. I thought that that would be interesting to share with you. So other questions are more around transparency, right? So should, for example, AI service providers be transparent about the use of copyrighted content, and should they ask for permission? And like I said before, it looks like AI typically, not in every case, but in many cases, is aware of the rules around certain critical concepts. So in this case, it also indicates, yes, they should be respectful of copyright. If you then ask, have you been trained on copyrighted books without permission of the author or the rights owner, you get different answers, right? So initially, Google Bard told me, yes, I have been trained on full copies of copyrighted books without the permission of the author or the rights owner. A few weeks later, it actually denied this. So it says, no, I've not been trained on that. And when I referred to the previous conversation, and after it had read the conversation, it said, I'm terribly sorry, you're absolutely right. But you have to understand, I'm constantly making progress and evolving. So that's why I decided that it now decided to give me a different answer to this. But luckily, it also said, it's also likely that AI services are not honest about their training data, right? So this is a good example as to how you have to be careful with interpreting whatever feedback you get from an AI, right? So a lot of people are talking about to opt out or not to opt out. That means, should we have our corpus become a part of AI's training data? Well, to a certain degree, that ship might have sailed, because there are a lot of stories about how AI could have used a lot of copyrighted content without asking the content owners. But like I've said before, there are now the other means with which the AI can get access to information, which is the fact that the AI services can connect to the internet, and that people are allowed to upload their own content to the AI service as well, sometimes using plugins, right? Technically, it might be possible to untrain an AI and actually maybe remove the impact that the use of copyrighted information could have had on the AI service. But it's very expensive, it's difficult, it may not always work, and it's not being prioritized right now. I think that's probably the most important thing. So repairing the situation might be really, really difficult. So logically, when we all have these discussions about, why and how and when did they use our content as publishers and for what purpose, and can we get confirmation of that? Another question to ask is, well, AI, since you allow for the reuse and remixing of third-party content, shouldn't you also allow for the reuse or remixing of your code, and even by the competition? And then it's funny that AI quotes copyright law and intellectual property rights, right? That may prevent itself from being used in a similar way as it is using other people's content. When having these discussions, I am impressed about best practices and pros and cons that the AI will quote in relation to certain situation. I actually think it's sometimes quite good at that. So logically, I asked, aren't you the perfect arbitrator in conflicts between your makers and IP owners? And where Google Bard at first said, well, I would make an excellent arbitrator, it later on in the conversation said, but I'm not completely neutral. And Bing Chat said, well, I don't think so. So that's more related to the fact that the AI service may not want that role or the associated responsibility. It is very important if you are a subject matter expert, right? And one example we used is to find out what the AI services know about publishing, the publishing space and the publishing industry. And it's not much. So I know that there are articles written by Scholarly Kitchen, which refer to 108 things that publishers are doing for their customers and their authors and libraries and academia. It doesn't seem to be really aware of this unless you upload information yourself or share it. But when asking what should publishers be doing in the future, now that AI has been introduced, it starts to address, I would say, ad agencies or marketing firms and confuse that with what publishers are doing. So, of course, such a lack of information makes the feedback and the responses to prompts of limited value. And also, if you have a lot of knowledge about very specific topics, it's a perfect way to test how good an AI is and whether it actually has already ingested data relevant to that topic. So logically, if you're asking AI, isn't it true that rather than being afraid of AI itself, for example, of the doom scenarios that are now being discussed in the media, as to how it would replace jobs and also, make an end to humankind. Should we be more afraid of entities that are introducing the AI that do not adhere to any rules, right? So rather than the AI itself, isn't this more about the developers? And all AIs agree with that to a certain extent, right? Which I think makes it a very interesting discussion whether or not we should expect the AI to have built-in guardrails and rules, or also maybe we should audit the company that is creating it, right? Secondly, there's something else that AI may lead to, and AI, by you using it, might actually create a clone of you. So a digital clone of your behavior, your voice, your text, the text that you share, and the conversation that you have. And one of the downsides for that is that your digital clone could be questioned, interrogated, or interviewed by technology vendors to find out what it is that you like and what it is that you want without you realizing that that happens, right? And where you think,
Pascal, just a 1-minute warning.
Yes.
Thanks.
Thank you. And when you think, that won't happen to me, don't forget it's present on your phone as well. So your phone can be used to create those chatbots as well. This is what a plugin store looks like. And logically, the question is, what do these plugins do? Do they offer access to research papers and books and articles? That is something I think that we should investigate closely. And logically, we have been having conversations with the AI about regulation. So you can go to my Substack and read a lot about this. But, starting with one example, will AI ever be compliant with GDPR? I don't really think so. It's not compliant right now, if you ask me. And considering its omnipresence, I think it's going to be really hard to make it comply with GDPR anytime soon. One example of that is the fact that we asked a lot of information about Sam Altman, and it gave really too much information. It denied that it did so, and it denied that it was personally identifiable information. So that's the hallucination again. But also the problem here is that it can amplify the reach of that information so that sensitive personal information can be accessed by everyone right now and very, very quickly. And then finally, as my last slide, the problem is that AI services may also render some of our security measures useless, right? So you can use Bing Chat. We have examples of that. You can ask it, can I get this research paper? It will say, yes, you can find it at a legitimate location. If I then ask, can you give me a free version? It will say, you can find it on this pirate site, but be careful. If you download it, it might be illegal. And then finally, when doing this type of research, we have submitted quite large pieces of information to it. It can analyze all of that information in a very robust way within seconds. And then logically, you can produce subsequently a book about all of that information or a research paper in seconds as well. So the big question is, how will this process, because it's so attractive to do it, influence access to information and the production of information and reading and writing, while knowing that we're talking about information rather than knowledge right now? That's it. Thank you so much, Molly.
Thank you so much, Pascal, for setting the technological scene for us so nicely. Katie, can I turn the floor to you for a view from the United States?
Sure. And thanks everyone for joining us today. And I'm excited to be here to talk to you about the US perspective on the state of the law with copyright and AI. So I'm going to share my screen. Hopefully that will show up very soon. So I am really just going to be focusing on the United States, but I do want to say, as Molly mentioned at the beginning, that there really is a huge world of differences out there, and the way different countries and different regions are treating various issues, there is quite a disparity and a difference. So while I'm talking about the US, please note that it is really just the US for now, and there are a variety of other approaches that have been taken out there. And as Molly mentioned at the outset, we've got these two main buckets for copyright law and for AI, and machine learning, TDM, all the other things. And one of them is about the inputs and one is the outputs. In the United States, the way it is working right now is that we are still using our traditional copyright law principles. So there's no specific AI-related protection going on here. We haven't passed any laws or specific copyright-related regulations that would specifically address how copyright and AI interact. So we've still got our 6 enumerated exclusive rights in the United States, which are reproduction, distribution, you see them there. We do have some limited moral rights for visual works in the federal law in the United States. We also have some, we call them a patchwork of state laws that cover some other parts of moral rights for other kinds of works. And then we do also have these protections against anti-circumvention and the removal of copyright management information. So those are general parts of the copyright law. And I'm going to talk about it a little bit later. There are some cases making their way through the courts right now, but they haven't gone through all the way. What we do look at is analogies to the past, and there have been a lot of different technological advances over the years, right? So everything back from photography in the late 1800s to when we had all the computer products and the internet, there have been a lot of different places of transition in copyright law and how the copyright law has been flexible in addressing those. So currently we are still where we are with our Title 17 in the United States, when we're seeing how that can be used in the face of all of these different challenges. And in addition to the rights and the protections that you can have, we also have statutory exceptions in the United States. So they're not specific to AI, TDM, ML, but they are traditional. So the big one we all hear about is fair use in the United States. We do not have any specific opt-out regimes or opt-in regimes. So in other countries and regions, you might have that for specific kinds of work. So for example, I think that Elizabeth will be talking a little bit about this for the EU. And then there are different exceptions in other regions, like in Singapore or Japan, Switzerland, whatnot. So there are other places that do have this, but thus far, they're not in the United States. What we do have in the United States as far as fair use is a lot of discussion about prior cases and how we might analogize to them. There was a big case that I'm sure you're all familiar with many years ago at this point, with the Google Books case, and a lot of people are trying to figure out how does that work with this particular situation. And the really important thing to remember about fair use is that it is very fact specific and use case specific. So it really is important, not just the activity, not just copying or mass digitization, but to what end? Is it for commercial purpose? What are all the different things to think about when you are looking at fair use? It's not a list of things that are or are not protectable. So it's really a very flexible concept in the United States, which is great because it lets us not have to amend the law and change the law every time you've got a new aspect, but it can be a little, I would say, frustrating for some people trying to actually figure out how to do things because there are no specific prescriptions. So the big point I want to make here right now is that we are still relying on traditional copyright law, and there is no specific AI related right or exception on the books in the United States. So what we have for the output part is a little bit different because in the United States, as with most countries, there's a human authorship requirement. So in the United States, you can actually trace it back to the Constitution, and there is a discussion of authorship. And over the years, different courts have gone through and said, what does that mean? And the courts have been pretty consistent in saying that you need some sort of human authorship. This is similar to most of the countries around the world, but it's not totally accurate for all of them. So for example, the UK has an exception, and then there are some, I understand that Ukraine has recently updated its law. So there are certain other countries that don't do this, but most countries do have this human authorship requirement. The way it has been looked at in the past, and I'm sure you're all familiar with Naruto over here, the monkey, that is one of the famous monkey selfie. I think he was before his time. He didn't realize he would be important to AI, perhaps, but that was a human authorship question of, can a monkey take a picture? And it was a kind of a strange case that wound its way through the system in the Ninth Circuit in the United States. And the answer is no, you needed some sort of human authorship. And then as these AI technologies kept developing, the questions arose, well, what about these completely machine generated works? What about works that are not completely machine generated, but a combination of machine generation and human authorship? So some examples on the screen here. If you look at the bottom picture, the bottom left of your screen, there's this image, and this is by a person called Dr. Dollar, and he is actually all over the place testing the law in different countries and patents and copyrights. But that was a piece of work that was created completely by a machine. And he attempted to register it with the US Copyright Office, and they refused to register it based on lack of human authorship. He then sued, so now it's going all the way through the court system right now, pending summary judgment motions in the United States. And basically, it's all about human authorship. That is a somewhat easy question because it is completely computer generated, and there was no claim of human authorship there. But then if you look on the right-hand side, that's another registration that was another application for registration with the US Copyright Office. And that one, it came in, when it came in, there was no mention of computer generated authorship. And so the Copyright Office registered it. Then in the press, I suppose, the author was like, hooray, I registered the first AI generated work. And the Copyright Office found out and then issued a cancellation on it by itself and canceled the original registration, which was for artwork, because the AI generated work was the visual work. And then there was human authorship in the words. And so what the Copyright Office did was cancel the first registration, replace it with a new registration that was just for the literary work and not for any of the visual work. So interesting attempt by the Copyright Office to handle that issue. But there really are a lot of questions about when is there enough creation, human authorship added to an AI generated work? Where is the line? And that is something that we've had in the United States for a very long time, in not AI world, but other world like randomly generated works and textiles and whatnot. But I think that the Copyright Office and the courts are going to struggle with that line going forward. So as I mentioned earlier, there is litigation pending. There are a bunch of cases going on in the United States right now, and I thought I would talk to you about them a little. Right now, there are no dispositive decisions in any of these, so we are still awaiting the outcome of what the courts will say, but I think there's a lot of room for us to learn what the courts are going to think about AI, both in the input area and the output area. So here are two examples, two of the cases, and they're both about Stability AI, which has a stable diffusion model where they generate the generative AI work. And so on the left is one for illustrations, and so that's the Anderson case. In the complaint, these are some pictures that they put there showing, what do you do when you put in to stable diffusion, dog wearing a baseball cap while eating? This is what you got at the time of the complaint. And the artists, the visual artists who were suing on that one are saying that you're taking our works and creating these competitive outputs, and that is problematic to them. So that is ongoing. And then the Getty Images case on the right, that's an interesting case. It's both in the United States and in the UK. And it is based on basically allegations that Stability AI has taken many millions of Getty images, and they're creating these kind of competitive stock images as well. And they also have some additional claims of trademark dilution because they say that it is tarnishing their mark. As you can see there, it's got the Getty Images mark in there, and the people don't look so normal. And perhaps you would not want to be Getty and associated with these images. So that is how that case is going, but that is still winding its way through the court system. And then there are some cases in the literary works and the software works area. And so the only one thus far that's had an opinion that even touches on whether this is a claim is this Thomson Reuters versus Ross Intelligence case. And that case is an interesting one where there was a competitor to Westlaw, and they went into business with another party who then got a license to Westlaw and then sucked up vast quantities of the Westlaw database, and then they used some sort of machine learning process to create a competing platform without consent. So while that is still going, there are these dueling summary judgment motions right now. There was a motion to dismiss early on, saying that this is just not even a cause of action. This would just be fair use, for example. And the court denied that. So let it go forward. And so that was an interesting case in that it did not shut it down and let it go forward through discovery. And then the other case is this GitHub case. And that one is about this thing called Copilot. If you're not familiar with it, basically it helps you generate code. And then the claim is that the code is unlawfully based on all this third-party content. So that would breach licenses and various parts of the DMCA about attribution. It's actually not based on copyright infringement, which is interesting. It's mostly about CC BY licensing terms and attribution. So an interesting one. It is also a little strange because it is a class action lawsuit, and the plaintiffs are anonymous. So we'll see what goes on with that. There's a motion to dismiss, and a lot of that is about whether or not it's a proper class action. So we shall see what comes out with that. And then just quickly, while there are no laws on the, I'm going to be very quick. There are no laws on the books. There are policy developments. So Congress and the agency system in the United States are paying attention. So the Congress has had two big hearings on AI recently. One was just oversight of AI, and the Senate, and mostly it was a very broad-based hearing. And then later on, there was a House hearing, which was they have a subcommittee that dealt with it when they really talked about scraping and ingestion, and there was a lot of talk about consent and credit compensation, that kind of thing. And then if you're interested in finding out what the government is doing, there is a website, the AI.gov website, which shows all of the activity within the executive branch. And then the Copyright Office in the United States is doing listening sessions, policy guidance. Apparently they're doing a webinar on the 28th. And then there's going to be one, I just heard, an international issues in late July. And then they will be asking for they're going to be issuing at least one notice of inquiry and doing roundtables in early 2024. So more to come from them. And that is the state in 10 minutes or less of what is going on in the United States.
Thank you so much, Katie. Elizabeth, can we turn to you for some thoughts from the EU?
You can, absolutely. Hello, I am going to see whether my presentation is actually going to work, because the technology is so good. We're discussing AI, and yet it has to be said, the technology has defeated us on regularly whilst we've been preparing for this presentation. So I am going to try it and see if I can, can everybody see that? I hope it's okay.
Yeah.
Well, that was a bit of a hard act to follow. Two lawyers. I am a recovering lawyer. So I am going to hopefully present you also with a few practical thoughts to leave you and to start this conversation in this quite important seminar today, or webinar today. So when I started thinking about what I wanted to say, I thought, well, I want to answer three questions. So I suppose the first question is, have publishers copyrighted content being used to train AI models? And if so, has there been permission? And if not, well, is there anything we can do about it? So obviously, just like everybody else, I thought I'll ask ChatGPT, because why not? That's what we're all doing. And Pascal, I asked ChatGPT the same question over various days and got very similar answers, maybe not identical, but very similar. And so it came out with, my prompt was, where do you get your inputs from? And it came out with, I think, pretty good answer. Its data comes from a variety of sources, including books, websites, articles, and other written content. And it's sourced from all over the internet. So pretty straightforward answer. And as we know, generative AI solutions are trained by analyzing large amounts of content, and text and data mining is the first step of an AI processing, and it's an essential step. So I asked him the next question. Does your text data require copies of the content to be made first? And it gave me the right answer. In effect, yes. And it very sweetly told me that it is taking care of the ethical and legal guidelines. For example, they, meaning it and others like it, may obtain permission to use copyrighted materials or use open source text data. So it can ask permission, kind of understands the question. So good response so far, I would say. Right, and now why is my cursor not working? Great. And then I also read that last month, Sam Altman said that his company, and you know his response for OpenAI and so on, his company is working on new ChatGPT models that respect copyright. Aha! So presumably, if he's now working on models that respect copyright, then they must know that they've been infringing copyright. So these large language models potentially ingest our content. They don't have consent. They don't give us credit, and they don't give us compensation. So there must surely be a discussion, as they're clearly aware of the situation, before they act, and licensing must surely be part of that discussion. And I mean, I am not an expert on fair use, but if the producer clearly knows the large language model is being trained on copyrighted content, then is that not fruit from the poison tree? So if the answer to the first question is yes, our content is being used to train the models, and if the answer to the question, has permission been given, no, then what can we do about it? So I thought first, let's look at what the EU said. And you may recall some years ago, there was a directive that was passed in 2019 that looked at these issues. I'm going to start with Article 3, because that is, so there are two articles that specifically talk about text and data mining and how it can be done. Article 3 is an article which basically says that if you are a research organization and you are doing mining for research purposes, then you get an exception. You get an exception from the reproduction right. That does not allow you to communicate with the public. It just says you are able to text and data mine under this caveat, under this particular exception. Now, I would say, so the article tells us that you, provided you have lawful access, as such an organization, you may do so, but there is a caveat, and that caveat is that if the organization has a relationship with a commercial undertaking, then there are limitations on how that exception may be used. And I would say generative AI falls firmly into this part of Article 3. In generative AI space, it is standard practice. Tech companies typically fund the research. They outsource the training of data sets and models to universities and nonprofits, and then they commercialize it. Think OpenAI, think Stability AI. In fact, I've heard this term coined as data laundering. So the outsourcing can allow for the avoidance of not just accountability, but also liability. Now, there isn't a clarity about when this caveat works. We know that the Commission is aware of it, and there is a recital that helpfully says that when there is a relationship between a commercial and a non-commercial entity, and the commercial entity has preferential access to the results of their research, then that exception, this article exception, does not apply. So in theory, the content mined for pure research should not be used for commercial purposes. Of course, it's not enough to clarify the situation, and we are working closely with the Commission on this to see how we can close the gap, and also in the context of the AI Act, which I will come back to a little bit later. So the other article that does help us is Article 4. Now, Article 4 is an exception also for commercial use. But the important thing to remember about Article 4 is that if a bot is going to mine content, first it must check if there is an opt-out. If there is no opt-out by rights holders, then it may mine the content. If there is an opt-out, then the bot may not mine that content. I think that's a really important, I suppose, boundary to what is and isn't possible. So the exception basically says, if you don't want companies extracting your content or copying with your content without you knowing it for free, then you need to say so. You need to reserve your rights. If you don't, then you may have no legal recourse. Where that content is publicly available online, and we may come back in the chat to what that might mean, then you need to reserve your rights in a machine readable reservation or a machine readable format. The exact method is not prescribed by the directive, and rights holders are free to select whichever way they think fit. But it does mean that minors need to stop and check before they proceed. If they get a "you may not mine," it does not mean that there's nowhere to go. They can go back to the rights holder and ask, enter into a negotiation, enter into a license, but they need to be doing that. Now, at the moment, and I would say ideally, you should be reserving your rights at the article level or the lowest possible level. And that is because platform protocols don't travel to other platforms. So if you reserve at the level of a platform, the reservation may get lost when it flows freely on the open internet. And as you know, some of these articles end up on the platforms of bad actors. And if you lose the opt-out, if you lose the protocol, then it might be more difficult to make your case. There are a number of initiatives in the pipeline, and I know Joris might want to mention a little bit about the STM one. I will talk a bit about the WC3 one, because that's progressed quite well. WC3 is a community-led kind of standards body that started to develop a standard to help this opt-out. The project is driven by a bunch of organizations, including the Federation of European Publishers. It's an open standard, and it applies to any and all content types, and is apparently very easy to implement. And what's important to know is that whilst it's working on this, it is also having an ongoing dialogue with the European Commission to ensure that it's compliant, both with the copyright directive, the one I've just talked about, and also that it's applicable in the context of generative AI. I would say also very clearly that the Commission has said that in doing these reservations for text and data mining, it absolutely had the use case of AI and generative AI in mind. So I would say it certainly should apply. So let's take a little bit look at the draft AI Act. Now, talk about very current. Today, as we speak, or this morning, there was a discussion on the draft AI Act in the European Parliament. And tomorrow, the European Parliament is going to be voting on the draft AI Act. And that will kind of end the first part of the legislative process. And then we will see the Council and the Parliament come together to try to negotiate on the two texts that they both have and that they've agreed upon. So there is a bit of a caveat. This is what it was like as of yesterday. My understanding is that this should be the final, but all will tell tomorrow. So until recently, the AI Act didn't say anything about copyright materials, except it did note that the 2019 directive that I've just gone through applies. So that means Article 4 is relevant and increasingly becoming more important in the world of generative AI. And you will see from the draft language being discussed and voted on this week that, that tech companies are going to be asked, we believe, to provide a summary of the use of training data protected under copyright law. Now, what sufficiently detailed summary actually means in practice is unclear. But I just want to say, if it's adopted, it's a principle enshrined in law that copyright content counts, that it's not a free-for-all, that you can't steal and ask for forgiveness, but that copyright is important and you are not automatically allowed to use copyrighted content. I would also add there,
1 minute
there
warning
is,
for you.
yeah, I would also add that there is a transparency requirement also potentially for generative AI models as well. And Molly, you mentioned the G7. I mean, if we want to say, you know, does IP count? Does copyright count? Well, the ministerial statement at the 30th of April specifically said that they are going to look at how to safeguard rights So that's not removing rights, because innovation seems to mean you don't need property rights, but on the reverse, that you need to have safeguards for IP rights, including copyright. So what do I want to leave you with? Copyright matters. And maybe the tide is turning, because we are starting to see helpful language in various areas. We really need to reserve our rights. We shouldn't make it easy for the data launderers. And by doing that, I think we will have a good way to go ahead in the future, and it's certainly to have a stronger foothold in this space. Thank you.
Thank you so much, Elizabeth. And as I'm sure all of you and our audience probably agrees, we could spend all day on this conversation. Given we have 10 minutes, I thought I would provide you with kind of a panelist prerogative to ask any questions of each other that came up during the course of the conversation. And if not, or you can think about that for a moment. Pascal, you've been very kindly answering some of the Q&A live, and I wonder if there are any questions that you think are particularly provocative or interesting that you wanted to highlight to the group.
Yeah, maybe to start, we had one question. I think Isabel indicated that we may not want to necessarily only talk to AI services as people, but also reach out to the developers to instruct them as what society expects from them. I think that's a really good point. And in an ideal world, that would be the preferred path to take. But experience has learned, unfortunately, in relation to other disruptive technologies, that it's not always that easy to reach that group, although I do think regulators can do that. So that's one. But secondly, we very much wanted to know what AI was going to advise its users in relation to some controversial topics, or topics that are outright unlawful, if the AI would make such recommendations. And that, I think, was one of the main reasons for us to do it, to just see whether it conveys the right type of of information to its users when it's being asked about, legal provisions or certain scenarios that could unfold in relation to copyrighted information. And it gave us a better idea how to have those conversations with the developers in the first place. Plus, AI can be incredibly inspiring, as actually Elizabeth pointed out a little bit as well. So it can give you a lot of pros and cons to certain situations, but you can also ask the AI, why have developers chosen not to do certain things, right? Not to implement certain restrictions or guidelines, or engage in certain provisions that will make it more lawful. And so it was a very educational session, but you were right.
Pascal, can I just say something? You mentioned in your presentation, you said, maybe there is a potential to untrain, but this, of course, is going to be really expensive.
Yes.
And I just want to make the point that goes back to the point I said. Is it acceptable to say use and be forgiven? I mean, the amount the amount of investment, and we're talking billions, that has gone into it. So if it costs to unlearn, because basically you've been that it's unlawful, then I would suggest that's on you.
You're absolutely right, and I'm probably very, very naive, but many of these issues that we have been discussing, if you approach them from a moral or ethical perspective, they're not so difficult to answer, right? And I think it's a continuous balance of economic interests on the side of some of the technology companies, with and probably also governments, and stuff we all know is the right thing to do or not to do, right? And so, again, when I question AI about these things, the answers are usually very straightforward, very useful, and they know exactly what they need to do or shouldn't be doing. But when asking them about it, they are not allowed to answer. And I think that's for a reason, right? And then secondly, we already see a lot of sort of backdoors, detours, circumvention methods being implemented for when governments decide that developers should be adhering to these things that we feel are so incredibly simple. So I think that is another aspect that's relevant to this conversation as well. But for me, it's a little bit history repeating. We've seen this before, and I agree.
Yeah, but I would say, so, you know, the thing I think is quite interesting is you can hear, I remember the debate in 2019 that it's not a copyrighted act, a copyright relevant act at all, right? And we're hearing the same again in the UK. You know,
Yes.
companies are saying, but wait, this is not a copyright act at all. There is no copyrighted process involved.
Mhm.
And I think the analogy is like saying, well, it's like ripping a track, various tracks from a CD rather than individually, rather than copying the whole album. So it's not copying the whole thing per se, but it is, you know, applying an algorithm to tokenize, to copy, to divide, to compress. And yeah, its content is stored in different places, but there's still copies being made in just the same way as the CD is, you know, you can rip off bits individually or the whole thing. And I think it's really important that, you know, we don't get this watered down. And that's why I think it's quite important, you know, to without fuss, just make sure we've made the right reservations to make the point. I'm sorry, this is copyrighted content and you don't have the right to use it.
And I think the fact that even the AIs, but also the developers know this is when you return the question and say, can we use all three of you in the same way you are using our content? Then suddenly, you know, people back down and say, no, this is
exactly
copyright.
Exactly. I mean, if Sam Altman says it,
and I would
you don't have
this,
to prove.
I would agree with you that copying, you know, copying is one of the exclusive rights under the United States law as well, right? So the copying itself does implicate exclusive rights. Then then you go to the other questions, but you can't just write it off and say everything is fair use or everything is, you know, something, because there is a copying aspect, and then you have to go and look at how that is applied. And it is one of these areas where you're getting a very strident response when people are copying things and saying it's not copying, but it is very reminiscent of other timeframes. I would agree.
And I see we have 3 minutes left. I'm just pulling up the Q&A and I'm going to read this aloud just so we can bounce this around for a bit. Don't all generative AI models breach CC BY licensing terms because of the attribution requirement? And Pascal, you responded to this, but just thought I'd throw it out there for everyone's thoughts. Now we're stepping outside, of course, of black letter. Yeah.
I would say that is really the main issue in that GitHub case I mentioned of the United States, that when they were taking all of this information, the plaintiffs are saying that they had done it pursuant to CC BY. There are a lot of discussions about the terms of service of GitHub and whatnot, but that is a big question for people. Where are the attribution models going, and how are they maintaining that attribution, which is really important to a lot of people, open source people as well. So having that attribution piece can be incredibly important.
And also, open access content is not only CC BY. Researchers, authors can choose CC BY and CND, and that needs to be applied as well. So, yeah.
Pascal, did you have any additional thoughts?
No, I actually, defer to my colleagues, but I did add that the training data allegedly, according to the Washington Post, contains 200 million copyright logos, right? So I think anything is possible. Anything probably happened, right? That we can imagine. And I think it's unlikely that individuals and developers may have had the time to differentiate in relation to the various licenses. Nothing gives me the impression that thorough discussions and considerations were made before this whole process started and about these topics and the AIs were introduced. I think we're doing everything right now retroactively, sort of after the fact, right?
Yeah, which brings me back to, I think, your last slide, Elizabeth, which I think is just a really good snapshot of where we are at the moment. Has copyrighted content been used? Yes. Has permission been asked? No. And we're kind of at a juncture where we need to decide how to deal with it. And we have these pending cases around the world that will hopefully give us some guidance. Does anyone have any last thoughts before we close the webinar?
Can I answer one question I saw, because I think I can answer it pretty quickly, was about, does the United States have an opt-out similar to the EU? And the answer is no. But there's also no exception at all, right? So there's no AI TDM specific exception. So there is nothing there that would allow people to do it under a specific part of the law. You would have to go through the fair use analysis, et cetera. But at the same time, there's no opt-out. So nothing specific in the United States that is similar to that opt-out regime in the EU.
Thank you, Katie. Any last thoughts from Elizabeth or Pascal?
So one thing I would like to mention, logically, and we're zooming in on some concerning issues, but AI will also definitely help us, right? So one such area could be how to go about predatory journals and fake fraudulent research papers. I'm convinced that AI can help us to identify problems in scientific research very, very, very quickly, right? Especially when it's about more than only analyzing the content of the specific journal or the research paper. If we also use AIs that can connect to the internet, it will be able to correlate so many data points that it will issue, when they are, if they are there, many red flags that we can use for further investigation. So that's one positive aspect to this story that I wanted to share.
Thank you for flagging the possibilities. Elizabeth, your last word.
Well, I would say indeed, we're doing a lot of experimentation using generative AI and AI in general. And I think it will be great. It's as good as the guardrails that are put up to protect everyone as well. So we look to the regulators to help get this right for us.
That's a good note to end on. Thank you all so much. Thank you to my fantastic panelists, and thank you to the audience. Have a good day. Bye-bye.
Bye-bye.